Hi, my name's Sasha Moore, and I'm delighted to be moderating today's legal update, an initiative from Unisearch, Australia's leading and most established provider of expert opinion services. This program has been created to provide bite-sized updates on various matters to help keep the profession informed about topical developments, legislative updates, and changes in the respective fields. Welcome and thank you for joining us. In today's session, we're going to draw upon the insights from one of Unisearch's esteemed experts, Mr. David Lyons, who specialises in design, materials, and causation, and will uncover, amongst other things, what a performance equipment failure, a capsized fishing vessel, and a modular building construction dispute have in common. That said, just bear in mind that the term causation is different from an expert witness's versus a legal perspective. So, an expert witness focuses on technical causation, not the legal responsibility. So, assessing how the failure occurred, why the materials or designs behaved in the way that they did, and what mechanisms link the design or material to the decisions and the outcome. So, on that note, welcome, David.
Thank you very much, Sasha.
So we're also joined here today by Unisearch's Business Development Manager, Christopher Aaron Yong. Christopher will provide additional context, including some commentary on how lawyers can maximise expert engagement in such matters. Welcome, Christopher.
Thanks, Sasha. Happy to be here.
Great to have you as always. So, I want to unpack the areas of design, traceability, and responsibility. So, David, I'm going to put the mic in your hands and I want to start with the fundamentals. So, let's just start with what the definition of design is.
So, Sasha, to an engineer, which is what I am, design is essentially the solution to a problem. And engineers approach the design task in a very structured way, which normally commences with some sort of a brief that they receive. And that structured way proceeds through conceptual design, much backwards and forwards discussion with stakeholders, through detailed design stages, right up to finalization. That's what design is to an engineer, but possibly to the person in the street, it's nothing more than how good something looks. They might say it's a good design.
Thank you. And as we were sort of talking offline, and sort of further to what you were saying, I understand it's really beyond the blueprint. So it's materials, it's fabrication, it's installation, modifications, use environment. So it's quite complex and therefore multidimensional. So
Uh,
on that note, we were also talking about how to recognize a design when you see it or recognize its absence, which sounds like a bit of a paradox. So talk me through that.
So perhaps sometimes in the business of being an expert witness, we're as engineers involved in looking at a problem when something has unfortunately gone wrong. So it's at that stage that the focus can shift back to the area of responsibility, and particularly who is the designer, who was the authority that claimed responsibility for that design. And it's not usually the case that it's as clear cut as the identification of one individual.
No, I would expect so. And so, on that note, what are some of the common assumptions versus the reality of this situation?
Well, the common assumption that you mentioned the term blueprint before, which is an old term that relates back to a kind of a machine that used to run off copies of paper drawings. Um, Engineers these days design objects of all sorts, from simple ones to complex systems, in a digital environment. And the connection between the design and the downstream manufacturing process for whatever that system or item is very much a linked continuum. Um, where design for manufacture, for example, is very important, that there's no point in designing something that can't be made. Designing for maintenance, designing for safety, designing for economic realization or considerations and realities are also factors.
No, indeed. And I guess also to that point, it's really looking at the life cycle. So you're looking at the design, which then leads to the fabrication, which leads to the installation, which leads to the use, and then the failure piece. So I guess that creates quite a multi-dimensional environment in which design matters are assessed. So Christopher, I'll throw to you. What are some of the associated challenges for legal teams for these types of matters?
Thanks, Sasha, and thanks, David, for your contribution. I think the one thing that we're seeing is that our experts are navigating that fine line between digital and non-digital matters quite a challenging process. So our experts and the instructing solicitors are engaged in really technically dense litigation requiring precise subject matter expertise. So that could be quite complex. But as you both touched on, it's all about that life cycle. And with that life cycle comes a problem, which is the cross claims or the potential or the opportunity for cross claims. And that's something that David, you had brought up previously when we were chatting offline. But I guess the other consideration here is the challenges that come with the timing of it all. The ability to engage an expert early, in the right time, as well as the correct timelines of the judicial process. So there's a bit of a trifecta happening with these challenges, the subject matter expertise, the cross claim itself, and the timing.
Thank you so much. So, David, I'll throw back to you. If we start to explore complex matters like this, can you provide a bit of an overview of some of the key questions that lawyers should be asking themselves, as Chris alluded to, sort of quite early on in a matter?
Well, very early on in the matter, Sasha, lawyers need to be trying to establish if there is a clear-cut identification of the design authority, and if there isn't, to continue to dig and to try and establish the reality of who consciously made decisions that led to the system or item, which was realized in the 3D, as it were, in the physical manifestation, as opposed to some early concept which never made it through to manufacture. Engineers these days have got ever more things on their plate. A few years ago, we weren't talking about design for sustainability or recyclability. Life cycle analysis was sometimes colloquially referred to as cradle to grave. Now it's sometimes, and more increasingly often, referred to as cradle to cradle, where the secondary cradle is the second life of what that system might be. So lawyers need to engage early. They need to seek our advice and counsel, if you like, as to what design really is, to help them look in the right place.
Indeed. And I'm also just taking from that life cycle piece that we talked to in the different stages that can lead to a disruption, failure, or other, is just going back to those core areas. So what was the original design intent, and what changes occurred during the fabrication or installation or usage, or who made those changes, and was that change foreseeable? And equally, how is that usage or maintenance controlled? So there are so many entities at so many different points. It actually blows my mind in terms of all of the nuances that need to be considered. So what I'd love to do is just to look into some sector diverse cases, because being a material expert sounds quite specific, but it's so broad in terms of all of the different areas, because any matter is a material, right? So what I'd love to do is to delve into some actual examples that you've been involved with, starting with a performance equipment failure. So tell me about that.
So performance equipment, so the sort of thing that I've been involved in that I'd like to just run past you is you have a performer in the arts. So they're relying on a piece of equipment that's made from some advanced materials that is assumed to provide them with a safe workplace, assuming that they're being paid, and even if they're not, it's essentially something that they should be entitled to rely on as being safe. So I'm a generalist, not a niche person. So you're right. When you referred to materials as being quite broad, that's absolutely the case. So the performance equipment item proved to be something that was sourced from one manufacturer, and then it was combined with other things that were needed to make it useful for the performer in on the stage setting where the audience would see the performer um, doing their act. And there was a clear understanding once we looked into the problem, which was an injury, a serious injury to the performer, unfortunately, that the people who provided the follow-on items of equipment to make the system work clearly had never met the people who produced the basic piece of equipment in the first place. So there was no conductor leading the orchestra, if you like. And that is so often the case. So often we find that what ends up being put to use is not really the same as what was originally intended. Changes happen along the way.
Yeah, and I expect that sort of human error or that supply chain issue would be quite common. And in terms of then the manufacturers or other forecasting the potential of that, it wouldn't be negligent in intention, but obviously it can have catastrophic implications. So, Chris, moving to you in terms of your legal insight. We've talked about multiple links in the chain and, design alone not necessarily being the cause. What are some of your key takeaways from this type of environment?
Great question, Sasha. And I think David's constant use of the term assumptions is really important here. And this touches, of course, in the letters of instructions that the instructing solicitors are providing to David. But one of the things that we're noticing here from a legal perspective or the legal insight is that the best lawyers or the most ideal lawyers are taking a lot of time and effort to think about the assumptions that are going into their matters and the letters of instructions, as well as clear identifiable facts. So drawing to the sources of reference there. I think the other thing here is like the importance of the first principle thinking. So again, coming back to what David mentioned around different swim lanes of the experts in a particular matter, where there is multiple points of responsibility, it is really important for this instructing solicitor to really think about the origins of the responsibility. And then, Sasha, that touches on what you were mentioning around formulation, documentation, and contract support. So all different considerations, but I guess the key pattern that we're noticing is that solicitors are thinking more clearly and more precisely around the letter of instructions and how their assumptions and the facts are playing a role in how experts like David might provide their opinion.
And I think also just to further on what both of you are saying is that nothing should be taken superficially or from a basic insight. So my take from what we're talking about so far, anything to do with a material design, construction, engineering, that's where shadow experts, expert teams, et cetera, may be considered because it is so complex and it's not necessarily what seems to be at hand without that thorough multidimensional view. So let's move on to another matter, David, where a commercial fishing trawler capsized and legal teams were trying to determine the cause. Talk me through that.
Well, one of my disciplinary areas of expertise is naval architecture. So the design of anything that floats, ships, boats, and even things that operate beneath the surface intentionally, such as submarines. Um, Unfortunately, commercial fishing trawlers that operate in large numbers up and down the east coast of Australia and elsewhere around our country's coastline are operating in very hazardous environments. And there is a disconnect between the very well written standards and regulatory framework for commercial vessels, including fishing vessels, a disconnect between that and practice where I've found in numerous fishing vessel matters that I've been asked to look at that um, you mentioned the word capsize, so the stability of the vessel, which is its resistance to capsize, was never actually checked, even though there were rules saying you shall have this much stability and the consequences are dire. Capsize usually leads to sinking of the vessel. Um, for whatever reason, it's normally at 3 o'clock in the morning in the pitch dark, and I don't find it difficult, if you like, to establish causation in these things because unfortunately there's a really hard-baked sort of trunk of causation there, where the system, i.e., the fishing vessel, has failed to perform safely, and in this case, as a workplace for the crew on board.
Thank you. So, Christopher, from a legal perspective, what would be your perspective on how this could be addressed?
Thanks, Asha. And I think it's just to build on David's point there, it's both by design, so the vessel itself, as well as the complex nature of the regulation in which they operate. So the governing law of that ship or the vessel and the flag state, those also throw another spanner in the works and make it extremely complicated. One thing that we're noticing with our legal clients, both at national and international firms, is that they're thinking about technical responsibility quite closely. So, as you called out, design versus build versus manufacturing versus maintenance. But as well as that, not to use that term, but essentially having those clear swim lanes for these maritime admiralty type matters.
Thank you so much. So we'll go to one final example. So David, tell me about a modular building construction dispute that you were recently involved in.
Sure, Sasha. Well, modular buildings have been a thing, if you like, for decades now, whether it's residential or commercial or specialist applications, mining, for example, in remote locations. And that they need to perform in the environmental conditions that they're subject to. So it's weatherproofness, it's leak proofing, it's resistance to extremes of low and high temperatures and so forth. That sort of category of matters that I've had quite a lot of experience in can usually be simplified down through my eyes to matters of material performance. So thermal expansion and contraction, shrinkage, inappropriate selection of materials, a lack of understanding of what the loads are that those structures are subjected to, and then a failure to communicate all of that information in a way that finds itself used faithfully by the people who deploy those modular buildings.
Indeed, thank you. And again, Chris, I'll throw to you from a legal perspective, what's important to consider for matters like this?
Only that a lot of the special counsels are also interrogating further on that material selection piece and trying to pin that to the warranties that those materials are attached to, or the materials and the warranties and how they interplay.
Thank you. So we might move to some of the practical takeaways and risk management piece. So Christopher, staying with you, from a bird's eye view with visibility across multiple related matters, what are your recommendations to the profession who are involved with such cases?
There's a few things, I guess, like the key things, and a lot of it is covered in our Practitioner's Guide to Briefing Experts back in 2018. But I guess like the first and foremost things is like the importance of engaging and deploying multidisciplinary teams. That's really crucial because a lot of these litigators are dealing with complex subject matters, and that ability to kind of delineate between different areas of expertise is really important. Then it's then turning to thinking about site inspections. So, what is there a requirement for these experts to go out on site? Do they also need to examine the impacted materials? That's more of an operational point. But then the last bit, and it's really crucial in that operational piece, is just thinking about the document life cycle. We talked about the allocation of responsibility based on design records, fabrication changes, just ensuring that solicitors and their clients are aware of how documents are kept from an operational perspective to ensure that at the end of the day, the contractual risk allocation is ultra clear. So really, those three aspects are the key things that kind of shine when we chat with our clients.
Thank you. And David, we were also just talking offline that you've just come back from a site visit. I would expect from your perspective that that's quite crucial in terms of assessing a matter.
Absolutely. I very much prefer to be able to get out there and get my hands dirty and see something. No expert in a complex engineering matter wants to be cross-examined with the question, have you actually seen it? Where you have to truthfully say, no, I haven't. It's 9 times out of 10 a good idea and to see it, because the other 1 out of 10 is it doesn't exist anymore, so you can't see it.
Indeed, thank you. So, Chris, I'll just throw back to you in terms about the role of effective expert witness questions. What would you suggest there?
I guess the key thing there is just bearing that end game in mind, as David mentioned. So if the instructing solicitor is quite clear and upfront that your matter will go to hearing, just being aware of like any assumptions that have gone into the report that you have written. That of course hinges on or is reliant on the solicitor being quite clear around their assumptions. And if they make mention to any facts, really calling out the sources of those materials. The only other build there is that from a document perspective, that you're making and they're being quite forthright and upcoming around the documents that are provided to the experts. And that, and at the end of the day, provides them with a holistic view, so long as those documents will bear a value in the expert's report.
Thank you. And David, I might just throw to you, having been an expert witness for such a period of time and of all sorts of matters, of all situations, what is your favorite type of engagement? What would be the best case scenario of how you're engaged, just so we can sort of reverse engineer that back to the legal profession who's listening in?
Sure, Sasha. Well, I don't need my life to be easy, but in receiving instructions, letter of instructions, if there are clear assumptions, if there are clear questions asked of me, if the material provided is also comprehensive and well catalogued, all of these things lead to a great start. And it's not always the case. I'll just very briefly mention one assumption that on a matter I was involved in about 5 years ago, which was an injury matter. A limb was lost where Firstly, I was told the assumption was that the person's limb was pulled into the machine, and then midway through, I was told no, actually the limb was lost when the person was being ejected from the machine. Neither is a good thing for the victim, of course, but it made the whole construct of how we went about analysing what could have happened, that technical causation that you spoke of, we were jumping through hoops. So we really like to see good assumptions, good questions wrapped up in a good set of instructions.
Thank you so much. So, Christopher, any final words from your perspective?
Only that it's the instructing solicitor has this ability to cut through, and that just speaks right to the heart of what David mentioned when it comes to the letter of instruction. But I guess like to take the higher, 30,000-foot view, it's just thinking about how thinking clearly around expert engagement might also play a role in the formulation of your trial strategy, and also bearing in mind how it ultimately will help the judiciary deliver well-reasoned and robust judgments. So, it's holistic. You're helping yourself, you're helping the judiciary, you're helping the expert, and at the end of the day, everyone wins.
Thank you. Well, thank you so much for your tremendous insights, David. We appreciate your commentary on why materials matter and the challenges of technical causation. Some of the key takeaways that I've taken are that design is wider than a blueprint. Responsibility really flows through the supply chain and the life cycle of a matter or a product, and causation in design and material failures are highly complex and multifactorial. Thank you, Chris, as always, for your commentary on how lawyers can maximize engagement with experts. And to the profession who's tuned in today, we hope that you found today's session insightful. And if you need to reach out to Unisearch to discuss any matter, please feel free to email Christopher at c.yong@unisearch.com.au. Until next time, goodbye.